Hello everyone, my name is Aarti and you're watching HW News. Breaking news at this moment is coming from Supreme Court. The rebel Shiv Sena MLAs today had moved to the Supreme Court against the disqualification notice issued against them by Deputy Speaker of Maharashtra Assembly Narhari Zirwal. Now the petition was heard in the Supreme Court today. As the crisis enters this legal arena, there were arguments being fielded from both the sides which were being heard in the Supreme Court today. Now I will tell you some of the highlights of the hearing. Moments before the hearing, a fresh application was moved by the Shinde faction before the Supreme Court. The new application stated that the lives of the rebel MLAs are under serious threat from the Shiv Sena cadre. The application said that the Mahavikas Aghadi government in state has lost control of law and order in the state. The application also referred to the statements that were made by Sanjay Raut, spokesperson of Shiv Sena, also its Rajya Sabha MP. Now, Sanjay Raut had yesterday said at a rally in Dahisar in Mumbai that the living corpses of the 40 rebel leaders will be back. He had also said that there is a Kamakhya temple in Guwahati in Assam and buffaloes are sacrificed there, and all these 40 MLAs have gone there to sacrifice themselves. Now, while the rebel MLAs have claimed it to be a threat, Sanjay Raut has said it is just a figure of speech. Senior advocate Neeraj Kishan Kaul started arguments in the Supreme Court on behalf of the petitioners today. The court then asked the Shinde camp why they did not go to the High Court first. Advocate Kaul said that Shinde and other MLAs did not approach the High Court as a minority of the legislative party. It's subverting the state machinery, attacking their houses. He said, and I quote, and you can also see it in the graphics on your screen right now, that he said, "They are threatening that our dead bodies will return from Assam. The atmosphere is not conducive for us to exercise our rights in Mumbai." This is what NK Kaul said. Now, Shinde camp's advocate Kaul then also read out extracts from the Arunachal case of Nabam Rebia on the power of speaker and disqualification proceedings. He questioned how can speaker decide of the disqualification of MLAs when there is a motion for removal of speaker pending against him. He then quotes the Nabam Rebia judgment of the Supreme Court, and again you can see it in the graphics on your screen right now. He quoted, and I also read out from the same extract that he quoted, "When the position of a speaker is under challenge through a notice of resolution for his removal, it would seem just and appropriate that the speaker first demonstrates his right to continue as such by winning support of the majority in the state legislature." He further says, why would a speaker who is confident of his majority fear a floor test? He reads this from Nabam Rebia decision of the Supreme Court. He goes on to say, the office of speaker with which the Constitution vests the authority to deal with disqualification petitions against MLAs must surely be a speaker who enjoys the confidence of the Assembly. However, the Supreme Court then asked him, what if the speaker survives the motion? If the speaker succeeds and his disqualification from the House is defeated, he can continue the disqualification proceedings. The Supreme Court then also asked Abhishek Manu Singhvi, who was representing Shiv Sena, and its Chief Whip Sunil Prabhu, his argument on this. When the hearing began, the Supreme Court, as I said, had asked the Shinde camp why the matter was not taken to the High Court first. Singhvi again raised this question in his opening argument, and asked by the SC this question he raised and said that Shinde Sena has not provided an explanation for the same. Singhvi questions the petitioners leapfrogging to the Supreme Court without approaching the High Court first. He said, no reason given by Mr. Kaul why your lordships should not exercise the discretion to send them to High Court. Referring to the past judgments of the Supreme Court, he then said the Deputy Speaker has the right to take a decision on the disqualification notices of rebel MLAs. A judicial review cannot take place when the proceedings in the Assembly are still pending. Responding to the rebels' argument that Deputy Speaker Narhari Zirwal cannot decide on MLA's disqualification notice when a no-trust vote is pending against him, his counsel Rajiv Dhawan said that no trust motion was rejected as it was sent via an unverified email address. Replying to this argument, Justice Suryakant then asked, and I quote, if Deputy Speaker is saying that he is rejecting the motion that seeks his removal, the question is, can the Deputy Speaker be the judge of his own court? The Supreme Court bench then issued notices to all the concerned parties and asked them to file an affidavit within 5 days. Now, time has been also extended for rebel MLAs to respond to Deputy Speaker's notice till July 12th, 5:30 p.m. The deadline that was given to them by the Speaker of the Assembly, Narhari zirwal, was today 5:30 p.m. But in a relief from the Supreme Court, this deadline has been extended to July 12th, 5:30 p.m. And in the meanwhile, the court has posted the next date of hearing to be July 11, and as of now, it is a relief for the rebel MLAs, as I said, since their disqualification has also been stayed. Now, do stay with HW News Network for all the updates related to Maharashtra political crisis. We have been tracking this story since it began 7 days ago, and we are still continuing to update you hour by hour what is happening in Maharashtra. Do let us know what you think about this in the comment box below, and do not forget to subscribe to our channel, like this video and comment below it, and do watch HW News.